Welcome in everyone to another live episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services is leveling up your legal knowledge about an area of law that we practice in. And we are delighted today to have with us again, Attorney Jack Cahoon from the law firm of Burnett Shutt McDaniel for part 2 of wrongful termination and the laws associated therewith. And so welcome, Jack.
Thanks, Susie. It's good to be back again. I hope everybody can hear me okay.
We can hear you just great. And this is part 2 of a 2-part series on wrongful termination. I just want to, before we get started, remind our audience that this is not legal advice. It's just general information for the public. But it's important. Important to you, it may be important to other people you know. So we do ask that after the broadcast, if you're live, please go to our YouTube page where a recording of the 2-part series will be located, and you can share it out and make sure that people who might need the information can get it. So if you're live, just go there. If you're on the replay, just go ahead and click share. If you feel like this is valuable, which I think you will. And if you're not subscribed to South Carolina Legal Services on YouTube, definitely go do that now as well, and turn on the notification. So every time we post an episode of Level Up Law, you'll get a notification. And that's a good way to find out about these. So now, we are on other social media, and we'll show you all of that at the end of the presentation and how you can get in touch with South Carolina Legal Services to see if you're eligible for our free legal services on this or other topics. And other than that, I think we're ready to go. And Jack, take it away.
Thanks, Susie. Thank you for coming back to Level Up Law. In our last session, we covered a lot of different legal theories that give employees various types of recourse for what one might call wrongful termination. We talked about common law claims for wrongful discharge in violation of public policy and breach of contract, handbook claims. We talked about Title VII and other types of employment discrimination laws that deal with race, gender, national origin, sex, religion, discrimination, disability discrimination. We have talked about various statutory protections for employees in South Carolina. We talked a little bit about protections for people who smoke, protections for expressing political opinions. So we've covered a few different grounds. Now we're moving into a big category called anti-discrimination laws. So that's what we're talking about next. And this is a really broad category. There's laws both at the federal and state level that prohibit discrimination against employees for various reasons. Let's see. So as we talked about, these are the protected classifications under various federal laws: race, color, religion, age for 40 people who are 40 and above, sex, including pregnancy, childbirth, lactation, related medical conditions, national origin, and disability. Each of these categories could be its own presentation, so we'll be covering these in a very superficial manner. We'll go into more detail if you need to talk with an attorney. That's a good idea, because there's always more detail and nuance and things that more facts we have to get to figure out if there's a case. One thing that's really important to know, though, is that the employer must have at least 15 employees for these laws to apply. So if the employer has fewer than 15 employees, then these legal protections don't apply. And they have to be proven either with direct evidence of discriminatory intent, or you have to be proven with evidence of disparate impact on a minority group. So like either there has to be evidence like somebody using language that's discriminatory, or expressing some sort of animus or hostility to individuals with certain traits, or you have to show that the particular policy has a greater impact on certain categories of people than others. And we talked a little bit, I think, about the burden, the McDonnell-Douglas burden shifting test. Basically, one of the first things one thing you have to have in order to have a lawsuit for discrimination is you have to show that you're a member of a protected class that was subject to an adverse employment action, that you're doing your job satisfactorily, and that there was an adverse employment action against you under circumstances giving rise to an inference of unlawful discrimination. What does that mean? So each of these things is something that becomes a battleground in a lawsuit. So membership in a protected class would be, if an individual's in like a minority group of some sort, or some other group that's meant to be protected under the law. Adverse employment action is an issue of dispute, so that typically is going to mean fired, demoted, suspended, something along those lines. It's hard to make a case for discrimination when it's just workplace conditions are difficult, or the employer treated somebody in a way that's unpleasant. It usually has to be something more than that. And you have to, the plaintiff in one of these cases has to show that they actually did their job well or satisfactorily. They're meeting their employer's expectations or reasonable expectations. And that last category of the action occurring under circumstances giving rise to an inference of unlawful discrimination typically is going to mean, that the employer gave a false or pretextual reason for the discharge. So if they said that if your employer said, hey, you were terminated for this reason, and that reason is not really, is provably false, that wasn't the real reason, then that's that last category. That gives rise to inference of unlawful discrimination. And then the burden shifts to the employer to try to articulate a legitimate non-discriminatory reason for its actions. So that's the fight that often occurs with employment discrimination. Now, we may have mentioned it, but I'm going to reemphasize it. In claims for discrimination, you have to be aware of the deadlines. So federal employment law, federal employees, like employees of the federal government, must go to their EEO officer within 45 days of the discriminatory action, or they may not be able to pursue a discrimination claim. That's a very short period of time. Other employees in South Carolina who are not federal employees have 300 days from the date of the discriminatory action to file a charge of discrimination with the EEOC, the Equal Employment Opportunity Commission, or the South Carolina Human Affairs Commission. And then if the EEOC completes its investigation, they have 90 days from that date of completion of and the issuance of a right to sue letter to file a lawsuit. So that they have 90 days from the receipt of right to sue letter to file a lawsuit. If any of those things don't happen in the necessary period of time, then the employees basically lost their right to pursue a discrimination claim. The only exception to this is the Equal Pay Act, and the Equal Pay Act provides 2 years from the date an employee received the last discriminatory paycheck to bring a lawsuit, or 3 years for willful discrimination. And the Equal Pay Act is a law that prohibits paying female employees less than males. All right, now we're getting into anti-retaliation laws. So these are provisions of law that prohibit terminating an employee or disciplining an employee for some reason related to their exercise of their rights. So the FMLA, Family Medical Leave Act, we're not going to get, again, this could be the subject of an entire presentation unto itself, but it provides up to 12 weeks of unpaid job protected leave for specific family and medical reasons for covered employees. And it only applies for certain employers. The employer has to have, among other things, has to have at least 50 employees in a certain geographic area for the FMLA to apply. It includes a non-retaliation provision, so employers can't retaliate against somebody or interfere with their ability to exercise their rights under FMLA. And there's a process to bring a lawsuit for retaliation under FMLA or to make an administrative complaint to the U.S. Department of Labor. Now, the Fair Labor Standards Act is a federal law that provides protections for minimum wage for certain employees that are in non-salary positions, and it also requires payment of time and a half for overtime for certain employees, and it also has protections against retaliation. So if an employee has made a complaint because they have not gotten paid properly, and the employer retaliates, that creates a basis for a lawsuit. There are 25 other federal whistleblower laws administered by OSHA, Occupational Safety and Health Administration, that cover many, many different types of situations. It could be employees who made complaints about asbestos or Section 11C of the Occupational Safety and Health Act, which prohibits retaliation for making safety complaints on the job, or truckers who are retaliated against for trying to make sure they follow the laws about not driving longer than they're supposed to. Each of these laws has a very specific requirement for the number of days in which it must be filed. So for example, that retaliation provision about workplace retaliation, workplace safety concerns being raised to OSHA, any complaints have to be made within 30 days of the retaliations. That means within a month after somebody getting terminated, they have to make their complaint to OSHA, or else they lose their right to pursue that. And some of these deadlines are 30, 90, 60, 180 days. There's also there's another law that comes up, the Food Modernization Safety Act. So if somebody's complained about the condition of a kitchen where like food's prepared for the public, that's one of those laws as well. If an employee works in a nuclear facility and makes complaints about conditions there, there's a provision of law for that. So there's just a laundry list of laws that may come into play that are considered whistleblower or anti-retaliation acts. And each one of them has a different process for making a complaint. Usually you can make a complaint through most of these through the website, the federal agency's website that administers the law. And each of these also has a little bit of a different package of rights and process for vindicating those rights. What I mean by that is they don't all provide for the ability to file a lawsuit. Many of these provisions have processes to allow individuals to go through administrative review of the termination or retaliation, and then maybe go before an administrative judge. So it's just something to be aware of. Let me go back to that. So you can, if you go to whistleblowers.gov, there's a website where that has all this stuff gathered together for employees who are regulated by the federal government who feel they may be whistleblowers. They can go there, and it's like clearinghouse of information and links to make complaints. Again, it's good to have an attorney through this process. And then another law that's very powerful is the National Labor Relations Act. And many people know about this law and think about it as being, focused on union activity. And it does cover, employees wanting to form a union, but it also covers much broader swath of activity on the job. It defines the rights of employees to organize and bargain collectively through representatives of their own choosing, but it also defines certain employer and union practices that constitute unfair labor practices. And we'll talk about that. It also covers, well, one thing to keep in mind is it does not protect supervisors or state employees. So if you're a supervisor or a manager, then this is not a law that's available to really draw on for protection. But in other situations, it can be very powerful. Section 7 of the NLRA provides that employees have the right, and I'm going to go skip to the relevant portion, to engage in other concerted activities for the purposes of collective bargaining or other mutual aid protection. All right. So what that means is, and the way the National Labor Relations Board has interpreted that, is that essentially anytime an employee is working together with another employee to engage in some sort of activity to address a workplace concern, that's considered protected activity. And they don't necessarily have to have anything at all to do with unions. It could be one employee talking with another employee about wages and benefits or other working conditions, or circulating a petition after asking for better hours. It could be participating in a concerted refusal to work in unsafe conditions, or openly talking about pay and benefits. Joining with coworkers to talk directly to the employer or to a government agency or the media about problems in the workplace. And a single employee can be considered to engage in protected concerted activity if they're acting on authority of other employees, like bringing group complaints to an employer's attention, trying to induce group action, or seeking to prepare for group action. So this is very, very broad. I've had cases involving employees circulating petitions. I've had cases involving employees jointly speaking up about concerns they have to their employer. And the National Labor Relations Board is very aggressive in pursuing these claims. I've also, the National Labor Relations Board has also found it to be a unfair labor practice to prohibit employees from discussing their wages. And many employers in the past have had policies saying that employees shouldn't discuss their pay with other employees. Well, the National Labor Relations Board has found that to be a violation. So, and I've had cases where the National Labor Relations Board has gone into the workplace and forced employers to post notices saying that that is an unlawful practice, and forcing employers to change that practice. Now, the National Labor Relations Act can offer employees reinstatement, back pay, and some other limited damages. There aren't any attorney's fees or punitive damages available under this law. And the deadline to make a complaint or a charge to the National Labor Relations Board is 180 days of the retaliation. So it's important to be aware of that deadline. The process to make a charge is to contact the National Labor Relations Board. They have a portal online for making a charge, or it can be done on paper too. This is all the contact information for that agency. Our local office of the NLRB is actually located in Winston-Salem, North Carolina. I found that office to be very helpful and easy to deal with compared to many other agencies. And if it's a case that they cover, if it's a situation that is covered by the National Labor Relations Act, they can be very aggressive in helping employees get resolution of these sorts of issues. So now, having gone on for two separate sessions of this presentation to cover all the material, I appreciate your patience. So we're going to skip. This presentation was originally focused for legal services attorneys. I wanted to talk about, for a moment, some tips for how to deal with concerns you have on the job. And this is something that, really, as an attorney, when somebody comes to me, I want them to talk to an attorney as early in the process as possible before they're terminated. If you feel like you're about to get terminated, then please reach out to legal services or reach out to a private attorney. And if you feel like it's wrong, it's good to talk to us sooner rather than later so we can help you come up with a strategy for how to handle the situation. But let's talk about some general practices that are a good idea. First off, it is a good idea to resist any effort to be forced to resign without talking to an attorney first. If an employer forces you to resign, you may be giving up serious rights under the law to get any sort of recourse. So before you resign, even if you feel like it's hopeless, it's a good idea to talk to an attorney. There's an idea that the courts generally have for many types of cases. One, that you have to exhaust your administrative remedies, or you have to bring the issue up to the attention of the employer, or that you basically have to give them a chance to fix the condition that exists before you resign. So that's almost always a better idea than to quit the job. Moreover, if you quit, you'll make it very hard to get unemployment benefits, or possibly impossible depending on the circumstances. So that'd be my first tip. My second tip is to create a paper trail. If you have concerns that you're expressing about the conditions at your work, it's good to go ahead and do that in writing and be specific. If you believe you're being discriminated against based on race, for instance, or your sexual orientation or something along those lines, you need to specifically state that in writing to your employer, to the right office at your employer. So the HR department or your direct supervisor, but in some way that it needs to be clear. If you have concerns about not getting paid properly, you need to write that, have a paper trail. It could be, it could be emails, it could be text messages, but it needs to be clear that you express those concerns, because it's hard to prove a case of retaliation if there's no written evidence that you made that complaint. That's another tip. If you have conversations with somebody at your employer, and one thing you can do is follow up with an email to them with a very brief summary of what you discussed, so that you have proof that you had that conversation. So you could say, hello, Suzanne, thank you for the conversation about my concerns regarding race discrimination. I appreciate you considering, looking into this. It's my understanding that the employer is going to perform an investigation. If you do that, then you have proof that that conversation occurred and that you raised the issue, right? And if they don't investigate it, then it shows that they didn't do what they said they were going to do. So creating your own paper trail is a good idea. Taking the high road, communicating in a direct but professional manner is always a good idea. So it's often, as employees, we don't want to rock the boat oftentimes, especially in the South. People don't like to have direct conflict about things, and that's not a bad instinct, but you still have to say exactly why you feel you've been discriminated against. And you have to say, if you feel like you've been discriminated against, be clear that it was because you believe it is because of your race or your age or your national origin or your sexual orientation or your disability. So being clear about those things, expressing it in a professional manner, avoiding curse words, avoiding name calling. The more professional you are, the better off you'll be with a jury, right? So you just imagine that every communication is being read by a judge or a jury, and you want to make sure that every conversation and every email is extremely professional, but also very clear about what you're saying. If you're not a manager, it's a good idea to have someone else jointly raise whatever concerns you have, right? So that's how that National Labor Relations Act comes into play. So if it's you and a colleague that are concerned about discrimination, then if y'all both express that concern, you may have a case not only under Title VII of the Civil Rights Act that prohibits race discrimination, but if you're retaliated against, you may also have a concern. You may also have a claim for under the National Labor Relations Act, which is a whole separate law that we just talked about. So, and here's the thing: the National Labor Relations Act it can cover many different things. It may be that the issue, your underlying concern is just that a supervisor is unprofessional or unpleasant. And normally, that wouldn't be something you can sue for. However, if you speak up about it with someone else, then it becomes protected under the National Labor Relations Act, so long as you're not a manager or a supervisor or a state employee. You can't be retaliated against. So there's lots of things you can do if you're thoughtful about it to protect yourself, and make sure that you have preserved your legal rights, and to make sure that you're in the best possible position if you do have to get a lawyer involved or to pursue a legal claim. So those are all some tips. The other thing I would just say is, it's a good idea to, if you feel like you're being discriminated against or that you might have some claim, you need to do your very best not to give the employer ammunition, right? So if somebody is, it can be a defense. The employer can raise it as a defense that somebody was excessively absent or excessively tardy, or out too much, or there's all kinds of things an employer can claim that might be a basis for them to get a lawsuit dismissed. So it's important that you don't give them that leverage, right? You want to make sure that you show up to work on time, that you do your job, that you meet your employer's expectations to the best of your ability, so it'll be really hard for them to try to retaliate, or at least for them to have a grounds for a discharge or other retaliatory act. And I don't know, that's about everything I have. I am happy to take any questions. I know this was not quite as long as my first presentation, but because we got through the material, but I'm happy to answer any questions anyone has.
Well, thank you so much, Jack, and appreciate you being willing to answer questions. It doesn't look like we have any right now, but let's just give that a minute. And I want to thank you again for not just doing one episode of Level Up Law, but for doing two. And those were great tips at the end. What a bonus for everyone in our audience to not only have all the the legal part of all these various laws that are out there, but also just to have some practical tips for when you face something like this regarding your employment. I'm going to
Well, thank you.
Attempt here to share my screen. Okay.
Okay.
A minute here. Oh, there we go. Share my screen. Just so our audience can see how to get in touch with us here. Can you see that?
Shows up. I see it.
Okay. There we go. Well, great. Yeah, this is how you can connect with us. You can check us out on all our social media platforms. We are always putting a lot of good information out there. Obviously, on our YouTube channel, we have the Level Up Law playlist and a host of other videos that aren't necessarily a Level Up Law episode. We have great attorneys here at South Carolina Legal Services, and we're always putting out as much important content as we can to share with our general public in South Carolina and throughout the state, obviously. And sometimes it's helpful for people who aren't even here in the state. So we do appreciate everybody following us on our social media. And I always like to point out that in 2023, once we were on TikTok, we actually had a TikTok go viral with well over 1 million or maybe even 2 million views. It was very exciting. So that right there goes to show you that we've got a lot of good content there. But the most important thing I think that you can take from what you're looking at right now is how to apply for our services. If you cannot afford a private attorney like the attorneys at Burnett Shutt McDaniel, where Jack is, or anywhere else, you can call South Carolina Legal Services at a toll-free number from anywhere. You can also go on our website, which is shown here, and apply online. And that's a great way to do it because that toll-free number is only available Monday through Thursday from 9 to 6. And sometimes you just can't make that call during those hours. So it's important that we have that online capability. You can also sign up to get emails and newsletters from us. So scan that QR code if you haven't done it already, and fill out the Google Doc that you'll see to give us all your information. And also, I do want to show this QR code, and that's so that if you have a particular area of law that you haven't found on our playlist and that you want us to talk about, just scan the QR code there and you can give us a suggestion about what would be an episode that you would be interested in. And if it's something that we have some expertise in or can find someone who does have some expertise, then we'll definitely put that into our planning as we continue throughout 2024. But boy, have we gotten a great start in 2024, which includes this great two-part series from you, Jack. And I just want to thank you again so much for doing this for us. And then thanks to our audience. We appreciate our audience both live and on the replay. We get a lot of views on our Level Up Law episodes, and we really appreciate that people are going there and accessing that information. So let me just mention that we will have another episode of Level Up Law next Tuesday at noon. We will be joined by Nick May from the Federal Trade Commission, and Nick will be talking about credit card laundering. All right, you've heard of money laundering. Well, there's something called credit card laundering that Nick is going to be sharing with us so that everybody out there who follows us or who may follow us in the future can find out what is credit card laundering, what's it all about, what should I be looking out for. So definitely check that out. You can go to our calendar at fclegal.org and sign up for that episode right now. You don't even have to wait for us to send you an email or anything. You can just sign up for it right now on our calendar. So definitely recommend that everybody do that. Let me just check one more time for any questions. And I don't see any. So Jack, you just covered this topic perfectly. And I think there were questions last time that you answered, and that's always good. So we do appreciate your willingness to answer questions. And
I'm happy to be here, Susie.
Yeah. Well, thanks again for joining us. Thank you so much for doing that, Jack. Thanks to our audience. That concludes this episode of Level Up Law. Take care, everybody.